So now I'll go into the appeal, the ruling, and I'll just read excerpts from it that I found to be important and relevant. This appeal requires us to consider whether the district court had jurisdiction to block the United States from using lawfully seized records in a criminal investigation. The answer is no. Lawrence O'Donnell brilliantly said that the 11th Circuit did something that Donald's parents never did, which is to say that the answer is no. And then, finally, somebody said it, and this one's going to stick, and there's nothing Donald can do about it. Only the narrowest circumstances permit a district court to invoke equitable jurisdiction. Such decisions must be exercised with caution and restraint, as equitable jurisdiction is appropriate only in exceptional cases where equity demands intervention. This is not one of them. Donald Trump makes arguments that, if consistently applied, would allow any subject of a search warrant to invoke a federal court's equitable jurisdiction. That understanding of Ritchie would make equitable jurisdiction not extraordinary, but instead quite ordinary. The callous disregard standard has not been met here. Let me start. The callous disregard standard has not been met here, and no one argues otherwise. The district court's entire reasoning about this factor was that it agrees with the government that, at least based on the record to date, there has not been a compelling showing of callous disregard for plaintiffs' constitutional rights. So that's the first bench slap to Aileen Cannon, saying that the district court reasoned by saying that there was no showing of callous disregard of plaintiffs' constitutional rights, and still went ahead with exercising equitable jurisdiction. Instead, he says callous disregard of his constitutional rights is not indispensable to the Ritchie test, meaning you can do away with it, which 50 years of legal precedents say you can't. It is the most important factor to see if there was a callous disregard of the plaintiff's constitutional rights. And the court agrees here by saying that is an incorrect reading of our precedent, as well as inconsistent with the long-standing principles outlined above. We will consider the remaining factors for the sake of completeness. And here the court says, in so many words, for the sake of completeness, meaning the other Ritchie factors are subordinate to the primary one, which is showing of callous disregard of the plaintiff's constitutional rights in order to warrant equitable jurisdiction, which is not there in the case, which Aileen Cannon herself conceded did not exist in the case. As to the other factors, the second Ritchie factor is whether the plaintiff has an individual interest in and need for the material whose return he seeks. Plaintiff's jurisdictional brief mischaracterized the standard, referring to the party's need for the seized material. Emphasis added to parties. He is wrong to suggest that the jurisdiction somehow depends on the balanced interests between the parties. The relevant inquiry is if he needs those documents, and plaintiff has made no such showing. He has asserted that the government improperly seized his passports, but the passports had already been returned before he filed his first motion, and his jurisdictional brief did not explain what similar materials were at issue or why he needed them. So there's a burden of proof here that Donald did not meet. And the 11th Circuit points that out. Courts have authorized equitable jurisdiction, have emphasized the importance of identifying specific documents and explaining the harm of their seizure and retention. Remember, again, the specificity requirement that I've talked about many times. Specific documents. And then another thing that I've talked about, harm. Explaining the harm. Those burdens are on Donald. He needs to show which documents and explain the harm. Neither the district court nor the plaintiff offered such specifics. So here, the 11th Circuit is not only saying that Donald Trump, who is a plaintiff in this case, didn't offer the specifics and therefore didn't meet the burden. They are saying that the district court didn't offer the specifics, therefore indicating the vast incompetence of Aileen Cannon in not regarding the basic tenets of American jurisprudence, of specificity and specifying harm and particularized harm. In the footnote regarding the documents that other personal effects that were taken, the court says in regards to Celine Dion's picture, plaintiff may have an interest in these items and others like them, but we do not see the need for their immediate return after seizure under a presumptively lawful search warrant. So as much as Donald may want Celine Dion's picture back, sorry, Donald, the 11th Circuit doesn't see the need for the immediate return of your Celine Dion picture. And I imagine Celine Dion is just creeped out that Donald is all up in her business with her picture. Indeed, back to the opinion. Indeed, plaintiff does not press the district court's theory on appeal. Instead, he argues that the Presidential Records Act gives him a possessory interest in seized documents. This argument is unresponsive. Even if the plaintiff's statutory interpretation were correct, a proposition that we neither consider nor endorse, personal interest in or ownership of a seized document is not synonymous with the need for its return. In most search warrants, the government seizes property that unambiguously belongs to the subject of a search. That cannot be enough to support equitable jurisdiction. Here, I want to point out that in parentheses, after talking about Donald's presidential records argument, the court makes clear a proposition that we neither consider nor endorse, meaning that they aren't even discussing the merits of this Presidential Records Act argument, because not only has Donald not built the record, which they talked about in the oral arguments, it's just not relevant here in this case. Plaintiff's task was to show why he needed the documents, not why the government did not. He has failed to meet this burden under this factor. Here, the 11th Circuit, again, implicitly does a masterful job of showing that Donald Trump needs to prove the claims he makes. His argument of why the government doesn't need them is not an argument that he needs to argue in order to meet the burden of proof. And this is something Donald does all the time in the court of public opinion, because this simple nuance of, throwing what ifs and blame shifting is just something that people do on a regular basis without understanding the inherent harm it causes or the circuitousness of these arguments. But here, the 11th Circuit makes it clear. Ritchie next asks whether the plaintiff would be irreparably injured by denial of the return of the property. In his jurisdictional brief, plaintiff suggested only that the government's continued custody of documents similar to his passport was likely to cause significant harm. The district court stepped in and offered its own reasoning. It identified potential irreparable harm that could arise based on 1, improper disclosure of sensitive information to the public, 2, the United States' retention and potential use of privileged material, and 3, the stigma associated with the threat of future prosecution. So here is this this 11th Circuit now stepping into, tearing into Aileen Cannon's opinion, just literally just bench slapping all over the place. Because I can feel the snark and the anger of the 11th Circuit, but in saying the district court stepped in with its own reasoning, without any precedent or any sort of backing by any ruling by the circuits or the Supreme Court. Its own reasoning, and the elements of the reasoning. So on the first argument, plaintiff echoes the district court and asserts that he faces unquantifiable potential harm by way of improper disclosure of sensitive information to the public. I brought this up in the previous because, the DOJ points this out as well. And, it was alarming for me to say that, to see that in the arguments made by Cannon and Donald. Any official who makes any proper disclosure of classified materials risks her own criminal liability. What's more, any leaks of classified material would be properly characterized as a harm to the United States and its citizens, not a personal injury to plaintiff. And I would go as far as to say that here, the 11th Circuit just, sort of sends out this warning that any official who makes an improper disclosure of classified materials risks her own criminal liability. Who is the her here? Donald Trump is not a her. And who is the other subject that the 11th Circuit is talking about in its ruling without taking a name? Aileen Cannon. I believe this reading over here is a warning to Aileen Cannon that any official who makes improper disclosure of classified material risks her own liability. And this is a one-off coming out of, talking about the first argument. As for the records that may otherwise be sensitive, it cannot be that prosecutors reading unprivileged documents seized pursuant to a lawful search warrant constitutes an irreparable injury for the purposes of asserting equitable jurisdiction. The district court's unsupported conclusion that government possession of seized evidence creates an unquantifiable risk of public disclosure is not enough to show that plaintiff faces irreparable harm. Similar reasoning guides our approach to the other potential injury identified by plaintiff, the threat and stigma of future criminal prosecution. No doubt, the threat of prosecution can weigh heavily on the mind of anyone under investigation. But without dismissing the seriousness of the burden, that ordinary experience cannot support extraordinary jurisdiction. Finally, Richie asks whether the plaintiff has an adequate remedy at law for the redress of his grievance. Here, we go back to the process of the investigation. The magistrate judge decided that issue when approving the warrant. To the extent that the categorization of these documents had legal relevance in future proceedings, the issue can be raised at that time. All these arguments are a sideshow. I mean, you can hear, I can hear. I mean, I've read appellate opinions and Supreme Court opinions, and this is the 11th Circuit's rage coming out against the reckless disregard for the rule of law that Aileen Cannon has had. And they're doing it as diplomatically as possible, but they're not being quiet about it. All these arguments are a sideshow, just like one sentence swoop. The real question that guides our analysis is adequate remedy for what? The answer is the same as it was with Chapman. No weight can be assigned to this factor because plaintiff did not assert that any rights had been violated, that there has been a callous disregard for his constitutional rights, or that his substantial interest in property interest is jeopardized. If there has been no constitutional violation, much less a serious one, then there is no harm to be remediated in the first place. This factor also weighs against exercising equitable jurisdiction. None of the Ritchie factors favor exercising equitable jurisdiction over this case. Plaintiff, however, asks to refashion our analysis in a way, if consistently applied, would make equitable jurisdiction available for every subject of every search warrant. And now here the 11th Circuit is specifically going after Donald Trump's just absurd arguments. He asks us to ignore our precedents, finding that a callous disregard for constitutional rights is indispensable. He asks us to conclude that a property interest in a seized item is sufficient need for its immediate return. Excuse me. He asks us to treat any stigma arising from the government's access to sensitive personal information or the threat of potential prosecution as irreparable injuries. And he asks us to find that he has no other remedy apart from equitable jurisdiction, even though he faces no remediable harm, no harm that can be remedied. Anyone could make these arguments, and accepting them would upend Ritchie, requiring federal courts to oversee routine criminal investigations beyond their constitutionally ascribed role of approving a search warrant based on showing of probable cause. Our precedents do not allow this, and neither does our constitutional structure. Here is talk about the separation of powers doctrine. The judiciary is constitutionally ascribed role of approving a search warrant, which Bruce Reinhart did. That is the oversight that the executive branch already has, and there's no showing that that process was in any way unconstitutional. The only one possible justification for equitable jurisdiction, let me start over. Only one possible justification for equitable jurisdiction remains. The plaintiff is the former president of the United States. It is indeed extraordinary for a warrant to be executed at the home of a former president, but not in a way that affects our legal analysis or otherwise gives the judiciary license to interfere in an ongoing investigation. The Ritchie test has been in place for nearly 50 years. Its limits apply no matter who the government is investigating. To create a special exception here would defy our nation's foundational principles that our laws apply to all, without regard to numbers, wealth, or rank. And this is a case from 1794 that the 11th Circuit cites the Supreme Court precedent, State of Georgia v. Brailsford, a 1794 case. It kind of gives me the chills to even say that. Like, it's invoking the powers of our constitutional order and bringing it to bear on these lawless miscreants, including Aileen Cannon. The law is clear. We cannot write a rule that allows any subject of a search warrant to block government investigations after the execution of the warrant. Nor can we write a rule that allows only former presidents to do so. Either approach would be a radical reordering of our case law, limiting the federal court's involvement in criminal investigations. And both would violate bedrock separation of powers limitations. Accordingly, we agree with the government that the district court improperly exercised equitable jurisdiction and that dismissal of the entire proceeding is required. And therefore, the court vacates and remands for dismissal of the underlying civil action, meaning the entire special master review is out.